Thank you very much. We almost met the quorum. We are here for one final case. We have a panel change. We are joined by Judge Hershfang, and Judge Neyman is still with us. The last case of the day is 2023 P112, GANSU TONGDA Fruit and Juice Beverage Company Limited versus STEINHAUSER, Inc. Mr. Follett.
Good morning, Your Honors, and may it please the Court. Jeffrey Follett for the defendants, appellants, STEINHAUSER, Inc., and Darren Jenkins. And rather than recap the brief, what I'd like to do today, if I can, is focus in on two instances where I think that the lower court or the plaintiffs have misstated or misapplied Massachusetts law. One of these relates to the Chapter 93A claim against Mr. Jenkins. That's argument number 3 in the briefs. The other relates to STEINHAUSER's affirmative claims against Hengtong, which is argument 4 in the brief. With respect to 93A, the error I want to focus on is that I think the trial court erred in the extent to which it misapplied Chapter 93A, Sections 11, primarily and substantially within the Commonwealth requirement. The court based its findings of liability for Mr. Jenkins on two categories of conduct that do not factor into the Chapter 93A analysis. The first is conduct that, while occurring in Massachusetts, was not unfair or deceptive as to Hengtong. And the second is conduct that the Superior Court found was wrongful, but that did not occur in or cause injury in Massachusetts. Where I start with is the language of Section 11 itself, which says that no action is to be brought unless the actions or transactions constituting the alleged unfair method of competition or the unfair or deceptive act or practice occurred, primarily and substantially in Massachusetts. Now, the Kuwaiti-Danish case gave a gloss on this to say you look to where the center of gravity of the circumstances giving rise to the case are. And read in isolation, you could look at the phrase center of gravity and think that you should be considering all the parties' contacts with Massachusetts or all of the facts of the case generally. But that's not what the statute or what Kuwaiti-Danish requires. You are only to be considering the alleged unfair and deceptive conduct and its consequences. The Kuwaiti-Danish case itself makes this point. At one point in the discussion, it's the SJC refers to certain policies of the defendant that were being challenged or that were being pointed to. And the court there said, because there was nothing unfair or deceptive about those policies, the fact that those policies were adopted and applied in Massachusetts cannot be considered on the question whether the wrongful conduct occurred primarily and substantially in Massachusetts.
Can I just pause you? I have two questions for you at this time about this argument. One, I take it, but I would like you to tell me if I'm wrong, that the primarily and substantially argument you're making here applies to Mr. Jenkins, but not to STEINHAUSER. Is that correct?
Yes. I mean, it could, frankly, apply to STEINHAUSER. We, in the end, STEINHAUSER has waived that argument. Mr. Jenkins advanced it, and I'll tell you candidly, it's just because I think the case is so extreme as to Mr. Jenkins that it just seemed more compelling, particularly where he didn't have any direct communications with the plaintiff.
So that leads to my second question, and I'm looking now at volume 3 of the record appendix starting on page 56 of the judge's decision, which is page 1567 of the volume of the appendix. Justice Wilkins wrote about 2.5 pages entitled Jenkins' Role and Massachusetts Contacts, in which he made a series of findings about that, including that, and I apologize in advance for completely butchering everybody's names, but we have no idea how to pronounce these things when we see them on the page. Mr. Kotab testified that he did not take any major action affecting STEINHAUSER's finances without consulting with and obtaining approval or acquiescence from Mr. Jenkins, which the court credited. That was finding 300. Finding 305 is Mr. Jenkins approved the structure by which Steinhauser made cash transfers from Steinhauser funds to Sono affiliates. And I'd pull those out just because they struck me, but there are other similar findings in that section. Now that I've talked for a while, I'm actually going to ask a question. In light of those findings, those factual findings by Justice Wilkins, how do you respond to those factual findings? Because I take your point that there were things that Steinhauser did at Jenkins' direction that may or may not have been unlawful or deceptive, but there are findings from the trial judge about these things that he found were unlawful and deceptive. How do you deal with that?
Sure. And I'd say first, when you consider the unlawful and deceptive acts, or the court's findings with relation to that, I'd say when you look through those findings include a bunch of, in that section, those findings include things that I think are extraneous, and I'll touch on in a moment, such as who signed a guarantee with the bank. There are instructions about, there were findings about what Mr. Kotab was instructed to do, and I think when you read the decision as a whole, what you find boiled down is there's a scheme the court talks about, or a way of operating that Steinhauser had, that Sono had, in terms of not securing contractual protections for assets and such.
And I think I see where you're going, and I'm interrupting, one, because unfortunately it's a flaw of mine, but two, because your time is limited, and I want to make sure you get everywhere you want to go. I take your argument. I think your argument is the judge found that there was sort of a MO for Steinhauser, and that it didn't come up as a result of this situation, that the company had been operating like that all along, and that's evident in the findings. The judge also found, though, to my read, that there was a point at which that MO became deceptive, and that was a point where the contracts at issue were being negotiated, and Steinhauser personnel were aware that they were affirmatively taking steps to pay money to parties that were not the plaintiff here. And so I'd like you to focus on the time that's at issue here, because I think that's really where the panel is going to be focusing and determining whether or not this was an appropriate decision by the lower court.
Sure. And what I'd start with saying is look at the court's discussion about what happened up to that time. And the discussion is there's a scheme. Here's how they operate. They do various things. But there's a lot of the scheme that the Superior Court is saying is not in itself a problem or is not unreasonable. It's not unreasonable to invest in the Brazilian affiliate. It's not unreasonable to prepay. And where it turns a corner in the court's estimation is, well, once you've kind of written off the company and you expect that it's not going to be around any longer, and yet you still are continuing with that MO.
Well, it was more than that, though, isn't it? I mean, didn't the judge essentially make a finding that, look, you're knowingly paying off related entities, you're making payments, you're benefiting your parent company, you're benefiting related parties, and you have no intention to make this $3.3 million payment or whatever it is to Hang Tong.
I don't think the court was saying that about the 3.3 in particular. I think it was just a little bit more that your...
There was a verdict on the 109A as well, right?
Yes, and 109A, by the way, is a remedy for what the court found was intentional wrongful behavior. And that's a remedy that was available. It was applied as to Sano. It was not applied as to Mr. Jenkins. The question is whether that same conduct is actionable under 93A as to Mr. Jenkins. And the crux of it is that the court's looking at these practices and says what makes the difference, once these transactions are continuing along, is that these are not being made for the benefit of Steinhauser. It's being made for the benefit of Sano. We're looking at a situation where decisions are being made in London to benefit the London company, the parent company, and to take action or not take action with respect to affiliates in the Netherlands and Ghana and Brazil. And all of this, by the way, is alleged to be causing injury to a party in China that's suffering injury in China. What happens in Massachusetts, to be sure, is implementation of a scheme that was decided upon in London. But what I'd say there is look to, for example, the language of the Yankee Candle case, where it's talking about, this is if you'll bear with me one moment, that it's a scheme conceived and concocted outside Massachusetts and visited overwhelmingly, in fact, I would say in this case exclusively, upon persons or entities outside of the Commonwealth.
I was just about to ask you what your best case is here, and understanding that there's a different calculus in every factual situation. But what would are your one or two best cases on this issue?
I'd say
support your position.
Yes, I'd say that you would look to Yankee Candle.
Yep.
Consider the Sonesta International versus Central Florida case, where the court notes that perhaps the draftsman or the legislature had in mind, by means of the disincentives of Chapter 93A, to improve the moral tone of business in the Commonwealth, but we're not interested in trying to impose our normative standards on other communities, especially when reaching beyond our borders might dampen the enthusiasm of outsiders to trade here.
Counsel, I don't want to cut this too short, but you said you had two things you wanted to focus on.
Oh, thank you, Your Honor. The other point is that with respect to the affirmative claims against Heng Tong,
the counterclaims, right?
The court has, to my mind, imposed an additional heightened requirement of being able to show that a defendant is on notice of specific fiduciary duties before that person can be held liable for aiding and abetting a breach of fiduciary duties.
So what, now I'm going to mangle a name again, Chakiris?
Yep, Mr. Chakiris, yes.
Chakiris, okay, thank you. What is the source of his purported fiduciary duty to the company?
Mr. Chakiris was a high-level employee in charge of sales at the company and sourcing, and at the time of while he was still under agreement with Steinhauser.
What agreement?
An employment agreement, which is in the record. But even apart from the employment agreement, just by virtue of the fact that he's one of the top guys, he and Mr. Nothelfer are the key sales and supply guys. And while they are both still working for Steinhauser, they begin diverting millions of dollars out the door to a competing business, Binder. And it would be one thing if Heng Tong is saying, I don't know anything about any of this, I'll sell to whoever wants, and I don't have any exclusive obligation with you, Steinhauser, so what? I don't need to know what the details are of Mr. Chakiris's agreement or Mr. Nothelfer's consulting agreement and what German law may or may not apply. And what I'd say in response to that is, it's one thing if Heng Tong is doing business with a competitor that has no relation to Steinhauser. It's another thing when people who you are still dealing with at Steinhauser are writing to you on private lines, are telling you, I can't meet with somebody because I'm not released from Steinhauser yet. You know, if within the space of a week you've got one email from Mr. Chakiris identifying his title at Steinhauser, and the next day you've got another communication from him saying, send that product over to the folks at Cott or at Coke. And not only did Heng Tong know about that continuing relationship, but Heng Tong intervened to provide material assistance by going out of its way to approach those customers.
So let me ask you two questions before
yes.
your time probably will run out, but you with our panel chief's permission, you can answer these. To succeed on the counterclaims, then, you're suggesting there does not need to be evidence that Nadelfer and Shakiris were officers or directors?
Correct.
Okay. My next question is, could you tell me, I see in your brief where you sort of lay this out, but the best evidence you have that they had knowledge of the breach of fiduciary duty, as I understand it, are the two emails, one where I think Nadelfer says, you know, use my home email, and I think the other email where there's a statement to the effect of, I'm not yet released by the company. I'm blanking on the name right now.
Yes,
by Steinhauser.
Right.
Jeez.
Those are the two best direct written documents. What I would point out to, what I would draw the court's attention to, though, and this goes back to the first argument, and we don't have time to get into that, but also consider the circumstances of the communications between Mr. Nadelfer and Heng Tong around the time of the handover of the big COT Cliffstar deal in late 2016, early 2017, where on one day, Binder USA, Binder Boston launches. On the next day, COT is saying, I'd like to place an order. And then what does Mr. Nadelfer, a Steinhauser employee, or actually a consultant, but within the sphere of trust at Steinhauser, is reaching out and trying to set up a meeting with Heng Tong at which Binder's principal is going to be coming, the head of the competing operation. And we're told that this meeting took place in January between Mr. Nadelfer and Heng Tong, and the trial court placed a lot of emphasis on this, right? That in January you have this meeting, and Nadelfer was really pleading the case about here's why maybe you ought to invest in Steinhauser, let's continue this relationship. And after that meeting, Heng Tong says, nope, we're likely to sue you. We don't really want to do business any longer with you. And the folks at Steinhauser and Sano particularly have a reaction of, oh, well, you're going to threaten us. We're not going to do business with you any longer. The Superior Court, trial court, really focused in on that, says, look at that sequence. That's the point where the folks at Sano must have decided we're ready to write off this Steinhauser investment. But what you're missing is the whole backstory that there's this clandestine meeting where they're supposedly talking about the Steinhauser-Heng Tong relationship, but lo and behold, there's a multi-million-dollar Binder deal.
I think we have at least one more question over here.
One more.
I hope a quick question. I've seen the Sano filings. Are there any Steinhauser filings, financial filings?
I think they are incorporated. I think they're just wrapped up into the same financial statement.
Does Steinhauser have any additional claims pending in other actions against Nadelfer and Shakiris?
No, those have been settled.
Okay. And then my final question, would you agree that the success of your first issue, severance, is contingent in part on the success of your summary judgment claim on appeal?
Or to put differently, if you lose the summary judgment argument, what prejudice can you show on the first issue?
I guess all I'd say is look to the common theme in that first issue. This goes back to what I was talking about, the clandestine meeting and the January piece. That the Superior Court, both in the discovery rulings and bifurcation and enforcement of bifurcation, there is a unwillingness to acknowledge that there might be it might shed some light on the facts and into the idea of what my clients intended to know that they may have thought they had a window of, fine, we're getting out of this business, but we got a year to do it. What they didn't know is we got a couple of weeks because all that business is going out the door.
Apologies to my colleagues. I have one final question. I did not see in the record a copy of your opposition to the Heng Tong motion to sever or a copy of your opposition to the motion for protective order. Am I just correct that that's just not part of the record appendix?
It's not part of the record, and unfortunately, I was not in the case at the time, so I couldn't answer specific
Okay.
questions relating to those.
Thank you.
Thank you very much.
Thank you.
We will hear from the other side.
Is this your computer?
Oh, yes, thank you, sorry.
Good afternoon, members of the panel. My name is Mike Kendall. I represent the Heng Tong companies. May it please the court. I'd like to first address the issue of Darren Jenkins and the 93A issue, given the primacy that he assigned to it, my brother. And I was pleased to see that Justice Hershfang immediately went to Judge Wilkins' findings of facts and conclusions of law. It's a classic Judge Wilkins document, meticulously documented, faithful to the record, 86 pages of just great judicial work. And of course, findings of fact...
How would you feel if he had come out the other way, though?
Excuse me?
Please continue.
Oh, I'd rather get the jokes than miss them.
I asked how you'd feel if he had come out the other way.
He didn't give us everything we asked for.
Fair.
Findings of facts are subject to a clear error standard. And so if we look at the findings of facts there, they clearly lay out that what was faithful to the record. Mr. Jenkins was Geppetto. He's the puppet master that pulled the strings, and Mohammed Kotab testified he did whatever Darrell Jenkins told him. Jenkins and Runge were the two shareholders that in effect ran the company. Jenkins ran it on a day-to-day basis. Jenkins may have been based in London, but Kotab, who was in Massachusetts, was CFO of Steinhauser, the Massachusetts company, CFO of Sono, the London company, where Jenkins worked from, CFO of Pinora, the company in Ghana, Africa, and CFO of Sono BV, which was the company in Europe. So by Jenkins' control over Kotab, from Massachusetts, he's directing all the transfer of funds, he's controlling the East-West Bank account, he's directing what type of payment plans can be offered and giving them some type of ratification or approval or authorization. I mean, it's consistent with, I believe, the decisions of the Makino decision and Indian Motorcycles, where if you have a typical agent-principal relationship, that can establish a principal outside of Massachusetts for doing work in Massachusetts. And given the incredible detail of Kotab's testimony, corroborated by endless emails and bank transfers and documents, it shows Darren Jenkins was running the show. Jenkins is a chartered accountant in London, the equivalent of a CPA in the United States. Kotab has an accounting degree from UMass and was a very diligent, hardworking guy. But Jenkins was both the boss in terms of authority and the boss in terms of expertise in sort of running these types of, fraudulent transfer type of manipulations. I think that there's little basis to disturb Judge Wilkins' findings there. If the court doesn't have any questions on that, I'll next go to the summary judgment issue. With respect to summary judgment, the record is undisputed. North Alpha had no fiduciary duties or contractual obligations to Steinhauser to not do business with us.
Was he an officer of Steinhauser?
He was, by contract, an independent consultant who worked for them. At one point, he had the title of president, but when Malpass came in...
That sounds important.
That sounds like an officer to me,
But timing is everything. Malpass comes in late 2016, and North Alpha loses the title of president. And he's sort of reduced, and he's not going to be selling, he's only going to be buying from the Chinese supplier.
when in 2016 did he cease being president?
I may be off by a few weeks, around September, October, maybe early November, around that time period. But before 2017, which is when I think the issues happened.
Was there evidence of any sort, even inferentially, that he was doing business with or taking steps to establish Binder at that point, or to work with Binder, I should say?
I can't give you the exact date. I'm afraid I don't have it exactly then, but more important is Malpass, who was the president and also the 30B6 witness, testified there was nothing in North Alpha's contract that limited him from doing business with us while he was also employed by Steinhauser. He's an independent contractor, and he was allowed to do business with other people. So if there's a fiduciary duty at all, it's only Chakiris's that would count.
Now, can I just interject? I mean, there are some emails and such in this case that can be seen as red flags. That it's, you know, when you're instructing someone, oh, don't communicate this way, right, on, you know, private email kind of messages. Are you saying that that's beside the point unless there's knowledge of a fiduciary duty?
What I'm saying is Malpass, as a 30B6 witness, testified North Alpha could do business with us, and that did not break any obligation. If he wants to keep private his business with one company from his business with another, I'd say that's a smart decision to do it. Why does he have to tell Steinhauser what he's doing with another company, even if he's allowed to do it? People keep competing business interests separate. There's nothing red flag about that. And, you know, whatever you may infer from certain facts or emails, I think Malpass's testimony is decisive. He's the 30B6, he's the president, he's the decision maker. He said absolutely, North Alpha had no contractual limitations in who he did business with. And he wasn't a fiduciary. He had been reduced in his authority, his title had been taken away. There's no reason to think that. And perhaps what is most helpful is the email that Steinhauser sent to us sometime in maybe Q2 or so of 2017, where they make some vague comment, you know, some Steinhauser former employees have some obligations to us. They never said, you can't deal with Chakiris. They never sent us an email and saying, you know, if Chakiris is doing anything, that's off limits. I don't know why they sent a vague email like that, probably because they had no right to limit Chakiris in the way they were doing. To answer your question, Justice Hershfang, Chakiris had a contractual obligation that was a non-compete. It got rewritten when he left in February of 17, and it sort of changed some of the terms. You know,
was there any evidence that Hang Tong knew of his non-compete?
No. Other than that vague email I just referred to where I would suggest there's no evidence, but whatever you want to infer from that, where they said there are some issues of some of our former employees. The never was a simple thing you can't buy from Chakiris. And it really didn't matter. The main relationship was North Alpha. North Alpha had worked for at least a decade or longer. It was a very close relationship between North Alpha and my clients. You know, what counterparties call a business partnership. They buy and sell, they don't have any real obligation, but after years of productive and good relationships, they like each other. And that's why Steinhauser could do the fraudulent transfers and get away from it, because the relationship with North Alpha, it was a sort of, what I think is not being, you know, unfair or sort of clumsy to say, there was a certain Chinese way of doing business. And if you have a relationship and a friendship and somebody that you have great respect for, there's a loyalty there. And it would be a tremendous insult and terrible feeling if North Alpha was ever thought of as a thief or a cheat, which he wasn't. So he was the front person and the face for Steinhauser, while Jenkins is manipulating the money. And my client liked to do business. Some of this is in findings of Judge Wilkins. They like to do business with North Alpha.
To what extent do we need to get into cultural differences in how business is done? Because, I mean,
really.
you've mentioned one example. Another example on the other side might be that personal payouts to do business are not considered ethical in some parts of the world and are in others.
You're going by what counsel has claimed, which is contrary to what the testimony was. The testimony of Tim Yi, I think is the last name, who was our witness from China who testified by Zoom, is that his company allowed him to do some separate brokerage deals for which he was paid that money. His bosses knew about it. They had some extra supply. He could go sell it on his own and make some money for himself, and that was allowed to be done. I don't consider that to be a payoff, and it certainly was never tied to any sort of bribery to cut them out and give it to somebody else.
But wouldn't that, however you characterize it, wouldn't that be considered an unusual arrangement in typical American business circles?
It didn't happen in the United States, so to be honest, I don't think it's as unusual in U.S. business circles as you might think, Your Honor, just I say respectfully. But his testimony was, for which there was no contradiction, is I could do a side deal to make some sales on my own. The company said it was okay. Things were taken care of appropriately. You know, the boss is letting me get a little extra income instead of giving me a raise in pay. I don't think that's such an uncommon situation, but I don't even see its relevance. So with respect to that, the issue goes down to, was there any evidence that we knew that Chakiris might have had some limitation? And I would suggest the email I referenced earlier, where Steinhauser makes a very vague description, should be used against it. If there was a limitation, they should have said it explicitly. By putting something in such vague terms without claiming it, if anybody would seem to indicate that's the strongest case they're putting in the email, not their weakest case or a case weaker than reality.
But, I mean, I'm assuming that that email that you're referring to was after February 28th, 2017, when Chakiris was released from his contract, having, as Steinhauser would put it, misrepresented to Steinhauser that he was not, that one, he didn't know where he was going next, he hadn't accepted employment or made a plan, and two, whatever he did, he wasn't going to be competing directly with Steinhauser's business.
I believe you're correct. It was after the February time frame, though I don't believe that the comments you've made about what he did or said in February have any relationship to my client. We sell juice to anybody who wants to come and buy it from us.
Even me?
As much as, if your credit is better than Steinhauser's, it would be a pleasure, Your Honor.
It's a toss-up.
We are one of the largest juice suppliers in the world, so we sold to most of Steinhauser's competitors, and that's something that, you know, we have no obligations or exclusivity to anybody. And that's why selling to Northelfer, whether it's Binder or Steinhauser, it's one of these businesses where there's lots of middlemen and jobbers and people buy and sell, and it's a real trading type of operation. And so there's no limitation on us. They knew that. There was no limitation on Northelfer. And whether there's a limitation on Chakiris, it's not anything we knew about. And I don't think they tied it to any contract that Chakiris actually got a contract. No, they talk about being put out of business from losing this business. They owe us like $3.3 million. This is a 1% to 2% profit margin. So if you sell $1 million, if Your Honor, if you decide as a moonlighting to sell $1 million worth of apple juice, you might make $20,000. There's no way that losing a contract for $2 or $3 million would put them out of business or have any financial impact. You know, when it's done properly, you sell the juice before you buy it, so you're guaranteed there's no loss and you know exactly what your profit's going to be, there's no risk. That's why it's a 1 or 2% business. You can do a large volume, make a small little steady percentage, and have no risk. It's when you start diverting the money to your other companies and you can't pay your suppliers, it then becomes a disaster. I want to add the last thing is, Your Honor, the reason why, I should have said this a moment earlier, why he's focusing on Darren Jenkins, because as you'll see from the papers, not only did Steinhauser do a very successful fraudulent transfer, so did Sono. The day before the trial, Sono moved all of its assets to another entity to try to escape liability for any judgment here. The centrality of Jenkins' argument is he's the only person who we might be able to chase and get to pay for it because all the companies have been stripped of their assets. I think I've dealt with the two issues that he's raised, unless the court has questions. I can briefly touch on the two other issues of the Zoom and the severance. I would suggest both of those a very experienced judge is trying to get the case moving. We were on the fast track when we filed this case in January 18, when Judge Yarushis severed the case in July of 2019. Virtually nothing had happened. We had had 4 motions to dismiss. We had very little discovery taking place. This is a case that was 4 witnesses on a bench trial that would take about 6 days to do, and that we hadn't even really gotten discovery going. So we were begging her for a trial date and to get the case moving. What was severed was a case, they wanted to do a counterclaim that had 9 witnesses, only 3 of whom would be appearing in our case, the Phase 1. The other 6 were additional witnesses. It was different facts, different law, and as noted, when they originally filed that case, they filed it separately and said it was unrelated to the Phase 1 case. And they just flipped their position, just trying to delay the trial, not for any substantive purpose or court efficiencies.
I'm going to give you 1 more minute, even though I think the questions are done, given that we allowed your...
And with respect to the Zoom, Your Honor, I felt like Chicken Little with the sky falling on me. After we finally got our trial started, after multiple delays, we had to bring in a discovery master, Judge Hinkle, to order them to produce the documents. We had 3 or 4 motions to compel to get the documents out of them. By the time we get to trial, COVID hits. You know, it wasn't the best timing. We wanted to go forward immediately with the Zoom stuff. They didn't. He gave them 7 months of waiting before their witnesses had to testify for Zoom. I think Judge Wilkins was quite indulgent of their desire to testify in person. They never came and said, we'll do the 14 days quarantine in a hotel in Massachusetts so we can testify live. They just wanted to delay the trial for as long as possible when they could come without the quarantine. He waited 7 months. I thought that was gracious enough of him, and it fits with the law.
Counsel, I think we're going to have to leave it there.
Okay. Thank you very much, Your Honor.
Thank you very much. Excellent job, both in the briefing and the arguments by both sides. The case is submitted. This brings our session today to a close. Our thanks to the court officers and the clerks, and we are adjourned.